In this video, I will explain how to collect on a so-called judgment-proof debtor. These are the expert recovery tactics you need when you win the lawsuit but the other side flat out refuses to pay. And by the end of this video, you'll learn exactly how to track down hidden assets, use powerful legal tools most people never hear about, and turn that worthless piece of paper into real money in your pocket. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I have spent decades helping clients recover money that other lawyers told them was gone forever. Now, here is something that might surprise you. Winning the lawsuit isn't exactly the easy part. The hard part starts the moment the judge signs your judgment, because that is when the debtor just disappears. They stop answering calls, they hide behind shell companies, they move money offshore, and they sit there hoping that you're going to give up. And most people do give up, but you are not most people. That is why you are watching this video. So let me walk you through exactly what to do step by step. First, let me be clear about something. The term judgment proof is misleading. It makes people think the debtor is untouchable, that there is nothing you can do. That is almost never true. What judgment proof really means is that right now, at this moment, the debtor does not have obvious assets you can grab. They may not have a bank account in their name. They may not own real estate. They might not have a regular paycheck. But here's what most people miss. Situations change. People who are broke today come into money tomorrow. They inherit property. They land a new job. They sell a business. They win the lottery. I've actually seen that happen. And here's the key. In most states, your judgment is good for years. In Florida, for example, a judgment lasts for 20 years. That is 20 years where you can come back and collect at any time. So the first rule of judgment recovery is simple. Do not assume the situation is permanent. Time is on your side. And now the second thing most people miss is that the debtors lie. I cannot stress this enough. People who owe money are not honest about what they have. They will tell you they are broke while driving a leased Mercedes. They will claim they own nothing while their spouse holds title to $1 million home. Your job is to look past the story and find the truth. All right, so where do you start? You start with discovery. And I do not mean the kind of discovery you did during the lawsuit. I mean post-judgment discovery. This is a completely different animal. Post-judgment discovery gives you extraordinary power. You can haul that debtor into court and force them to answer questions under oath about every single asset that they own. This is called a debtor's examination, and it is one of the most underused tools in the legal system. During a debtor's examination, you can ask about bank accounts, real estate, vehicles, jewelry, business interests, income sources, and even transfers they made to family members. They have to answer truthfully, and if they lie, they face perjury charges. If they refuse to show up, the judge can issue a warrant for their arrest. Let me say that again, a warrant for their arrest. This is not a traffic ticket. This is serious. Now, beyond the debtor's examination, you should also be running asset searches. A good asset search will reveal bank accounts, brokerage accounts, real property, vehicles, business filings, and UCC liens. You would be amazed at what people forget to hide. I have found debtors who claim to be penniless sitting on rental properties in other states. I have uncovered hidden brokerage accounts worth 6 figures. The key is knowing where to look, and that takes experience. Once you find the asset, now comes the fun part, actually grabbing them. The most common tool is a writ of garnishment. A garnishment lets you seize money directly from a third party who owes money to your debtor. The most common example is a bank garnishment. You serve the writ on the bank freezes the account, the money gets turned over to you. The debtor wakes up one morning, checks their balance, and it's zero. That is a very effective wake-up call. You can also garnish wages. If the debtor has a job, you can take a percentage of every paycheck until the judgment is paid. In Florida, the rules around wage garnishment depend on whether the debtor qualifies as head of household. But in many cases, you can reach those wages. Then there is the writ of execution. This lets the sheriff physically seize property, cars, boats, equipment, inventory. The sheriff shows up and literally takes the property and sells it to the auction and then gives the proceeds over to you. Now here's a tactic that most attorneys overlook: charging orders. If your debtor owns an interest in an LLC or a partnership, you get a charging order against that interest. This means any distributions from that company gets directed to you. The debtor still owns the interest, but they cannot touch the money. It flows directly into your pocket. Now, if the debtor owns real estate, you record your judgment as a lien. Now, they cannot sell the property or finance it without dealing with you first. You are sitting right there on the title. They have to pay you to make you go away. Now, if you're finding this helpful, do me a quick favor and hit that like button and subscribe to my channel. I put up videos like this every single week to help you protect your business and your money. And one click makes a big difference. All right, let's keep going. Let me share some of the most advanced strategies I use with my clients. These are the tactics that separate amateur collectors from professionals. First, fraudulent transfer claims. If your debtor moved assets to a spouse, a relative, or a shell company to avoid paying you, that transfer may be voidable. Under the Uniform Voidable Transfers Act, you can go to the court and unwind those transfers. You can claw back the money or the property even from the person who received it. I've seen debtors transfer their home to their spouses the day after a judgment was entered. This is a textbook fraudulent transfer. The court will reverse it. And now you have a debtor who not only owes you money, but also looks terrible in front of the judge. Now, second, reverse piercing the corporate veil. If your debtor is hiding behind a corporation or LLC, you may be able to reach the company's assets to satisfy a personal judgment. Now, this requires showing that the debtor treated the company as their personal piggy bank, commingling funds, ignoring corporate formalities, and using company money for personal expenses. And third, domesticating your judgment in other states. If your debtor has assets in another state, you can register your judgment there and enforce it just as if a court in that state had entered it. This is done under the Uniform Enforcement of Foreign Judgments Act. Most states have adopted it, so if your debtor fled from Florida to Texas and bought a ranch, guess what? You can follow them. And fourth, if your debtor has assets overseas, international asset recovery is an option. And this is my specialty: tracing assets through offshore accounts. Foreign operations and international trusts require a specific skill set, but it is absolutely possible. I've recovered money from accounts in Switzerland, the Cayman Islands, Panama, and beyond. Now let me talk about something no one discusses: the psychology of debt collection. Most debtors are not criminal masterminds. They are people who got in over their heads and are now panicking. They hide because they do not know what else to do. They avoid you because facing the debt feels overwhelming. Understanding this gives you leverage. Sometimes the most effective tactic is not a garnishment or a lien. It is a well-crafted settlement offer. Once a debtor realizes you are serious, that you are not going away, that you have the tools and the willingness to use them, they often come to the table. I've settled judgments for significant amounts simply by demonstrating that I knew where the assets were. The debtor's attorney calls and suddenly they want to negotiate. Funny how that works. The key is persistence. Most judgment creditors give up after the first obstacle. The debtor says they are broke, the creditor shrugs and walks away. Don't be that person. Be the creditor who keeps looking. Be the creditor who uses every tool available, and be the creditor who makes the debtor understand that this judgment is not going away. Because here's the truth: debtors settle with the creditors they fear, not fear in a threatening way. Fear in this person is competent and relentless way. That is the reputation that you want. So let me bring this all together. A judgment-proof debtor is rarely truly judgment-proof. It is a temporary condition, not a permanent one. Your job is to investigate, be strategic, and be patient. Use post-judgment discovery, run asset searches, deploy garnishments, liens, and charging orders, and look for fraudulent transfers. Follow the money across state lines and even across borders, if that's necessary. And if you're sitting on a judgment right now that you thought was worthless, think again. There may be money out there waiting to be collected. You just need the right strategy and the right team. If you found value in this video, please like it and subscribe to my channel. Every new subscriber helps me reach more people who need this information. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.